Good afternoon, everyone, and welcome to this Open to Export webinar from the Institute of Export and International Trade. Today, we will be looking at what importers and exporters need to do to prepare for trade with the EU once the transition period finishes at the end of the year. My name is William Barnes-Graham, and I am the Senior Content Editor at the Institute. There are now just under 5 months until the transition period finishes, after which trade with the EU is going to change. The government has made a series of important announcements in recent weeks about exactly how things will change and what businesses can do to prepare. This includes the publication of the UK's border operating model, a three-phased plan for introducing controls on imports, new grant funding for businesses to prepare for new requirements such as completing customs declarations, and much more. We will be hearing more about all of these key developments throughout this webinar today. And I am delighted, as ever, to welcome Kevin Shakespeare, the Director of Stakeholder Engagement at the Institute, who is our main presenter today. Hi there, Kevin. How are you this cloudy but warm Tuesday?
Yeah, very good, Will. You're right. It's certainly warm but cloudy where I am. So thank you.
Absolutely. And Kevin has been leading the Institute's training and analysis around the UK's future trading relationship with the EU and is a regular speaker on our webinar programs. Now, just a couple of housekeeping notes before we get going. First, you can contact me with any comments or questions using the question panel on the control window to the right-hand side of your screen. And afterwards, you will receive access to today's slide pack and a recording of today's webinar in a follow-up email we will be sending over the next day or so. Now, if we move to the next slide, to begin today's webinar, we'll be running a few polls, but we're going to begin with this one, which is: how well prepared do you think your business is for the end of the transition period? And the options there range from very prepared, quite prepared, not very prepared, not at all prepared, or not sure. And Kevin, while people are answering that poll, you've been very close to this for quite some time. How prepared are the businesses you've been talking to on the ground, as it were, for the changed trade rules post-transition?
Yeah, it's always an interesting question. Thanks, Will. Certainly a lot of the businesses I speak to are certainly considering the planning, and some are going now into some depth in terms of their business planning. And it's probably fair to say that others are still considering, which I'm probably not talking to as much because they're still considering. I guess my concern would be those businesses that are not listening into these webinars as to how prepared are they, or are there some issues there that they're not necessarily considering. So we, through our various channels, Open to Export, the Institute of Export and International Trade, are keen that all businesses, no matter what you do, how big or small or medium you are, where you trade, that you look at these implications, because there will be something here which could be an action you need to take or an opportunity that will hopefully come out. Thank you.
Thank you, Kevin, and thank you to everyone who's already answered the poll. I'm just going to share the results now, and it does kind of tally with what you were saying there, Kevin. So 59% quite prepared, 8% very prepared, but as you say, a lot of people who probably aren't as prepared probably aren't on these webinars as of yet. And for those of you who are not yet prepared, hopefully today's webinar will be useful. It should be useful for everyone. But on that note, I think it is probably time for me to pass over to you, Kevin. So over to you.
Thank you very much indeed, and formally good afternoon everyone. Thank you very much for joining today. So I'm conscious some of you on the call today may have been involved, listed to previous webinars that through our various brands that the Institute has been involved in. I've also spoken with members of numerous trade associations, with devolved governments, administrations around the United Kingdom as well. So if you've heard me already, hopefully I'm going to say things that are that reinforce some of the messages you've been hearing, and also hopefully covering some new areas. So when we thought about the topics today, it it is quite feasible that we will duplicate some things in previous webinars, but equally we want to bring out some new areas here. So we want to focus today on service exporters as well. So the impact of post-transition trading on service exporters, and also recognise in some cases that service exporters will also have to move goods. And sometimes small parcels are not really considered as importing and exporting, but they are, and we'll look at the implications there. We'll also look at areas of rules of origin. Now, there'll be some areas that we've covered in various webinars, and we only have an hour today, like trade with the rest of the world, product compliance, the likes of CE marking, which we're not covering today. We have covered them in previous webinars, and do listen out, look at our back catalogue of webinars, masterclasses that we provided. But this is what we're going to cover today. So we are going to again focus on customs declarations, do a more quick overview of the border operating model and the free phase plan, we'll quickly look at GVMS, because a lot of talk of this lovely word GVMS, but what does it mean in practice, as well as rules of origin and service exporters. And again, I really want to make sure we get the points out on service exporters today as well. So if we can have a next slide, please. So in terms of trading in 2021, just a summary, almost like an executive summary here. So to confirm, on the 31st of December 2020, the transition period ends, and literally after decades of trading with the single market and the customs union, UK and EU businesses must be prepared for differences. And as I've said many times, it's not just UK businesses, it's EU businesses that are going to be impacted as well. And the level of awareness in the UK in some respects is higher than in a lot of the European Union. So if you have customers, suppliers, you need to engage with them, because they might not be getting the same level of information or access to information as you have. And a lot of these changes would apply irrespective of whether there's a trade deal. So one of the misconceptions, or what we hear a lot, is, well, if the UK and the EU strike a trade deal, then it's business as usual. Well, it's not. A trade deal could result in zero tariffs, and that clearly is a key, one of the biggest areas of uncertainty for businesses as to whether a trade deal will be struck. But that would be potentially the best case scenario in terms of impacts. Impacts on customs declarations, safety and security declarations, even for small parcels and for small value consignments, will also apply as well. And that brings into areas like VAT, and we'll talk about that today. And customs declarations, as I've said before, is not just about making the declaration, it's everything that goes with it around origin, valuation and customs compliance, which we'll also talk about. And if you've never listened to one of our webinars before on any topics, a special welcome to you today, and I hope you find it of benefit. So in terms of the European Union, they've advised all new procedures, which we'll talk about today, will be required from the 1st of January. The UK does have this some phasing of import controls, which we'll look at, and easements, but the EU have said it will be full implications, full procedures from the 1st of January. So if we have the next slide, please. So we're now going to look at customs declarations. We'll then start moving into responsibilities and then move on to origin, cover VAT and GVMS as well. So we have a next slide, please. So customs declarations, again, as we've probably said many times, the fact that the UK is leaving the customs territory, the customs union of the European Union, requires an outbound declaration for goods leaving the UK or leaving the EU, and an inbound declaration for goods entering the UK or goods entering the EU. So 2 declarations. And irrespective of who makes that declaration, an agent, a forwarder, the liability is on the trader, the importer and exporter. And as we will look at, and have looked at before, Incoterms determine that responsibility, ultimately as the declarant of record. And if we have the next slide, please. So this is a sort of chart I've used before, and I will quickly talk through it today, but maybe not spend too long on it. Is effectively you have the export stage. So again, bearing in mind that any goods sent or received sent to or received from the European Union will be an export and an import into the European Union if it goes from GB to EU. And you notice I'm using the term GB, Great Britain here, because there's different processes for Northern Ireland, which we'll refer to and we have referred to on other webinars and masterclasses. So if you don't have our back catalogue or access to our back catalogue, please raise that and we can provide links and information for you. Bearing in mind that some of those webinars took place 1 month or 2 months ago, and there may be some slight changes to them now. So the goods are available at the exporter's premises. They're loaded onto a lorry, which is a process. And the lorry then moves from the exporter's premises to the port of dispatch. But goods require to clear customs, not whilst we're in the transition period, but from the 1st of January next year. And the goods then, if they clear customs, but the declaration has to be made in advance of being received, effectively the lorry arriving at the port. And there's different timings on when that pre-lodgement notification is required, depending whether it's air freight, depending whether it's a containerized goods or roll-on, roll-off, ro-ro freight. So different timings apply. The goods then are loaded onto the vessel. The vessel moves from the port of dispatch to the port of arrival, but goods have to clear at the port of arrival as well. So an inbound declaration is also required in advance. And then the goods, if they clear customs, move through ultimately to be unloaded from a lorry at destination. Now, this applies for goods going from Great Britain to the Republic of Ireland, as well as the rest of the EU and the Republic of Ireland to Great Britain. Now, there is a special procedure or a customs procedure, or probably a better way of referring to it is a transit procedure, which can apply as well. And again, we can take questions on transit. We have covered transit separately. It's something that some of you on the call will be familiar with. If you're a freight forwarder, for example, it's definitely be a process you're very familiar with. But a number of things to consider there in terms of possible use of transit and as appropriate working with your freight forwarder. If we have the next slide, please. So exports to the EU or GB, so effectively when goods leave a customs territory, what is required? A export customs declaration is required in advance. UK exporters will need to zero rate their exports for VAT, but those of you familiar with Intrastat will still apply predominantly for record keeping purposes in 2021. There will be a requirement for a safety and security exit declaration because we're moving from one customs territory to another customs territory. So for example, GB to EU or EU to GB. There will be requirements on labelling, analysis and goods placed on the market depending on the nature of the product. There will be a requirement for origin certificates, and we'll speak more about origin later on. If you have temporary exports, I'm conscious there's been several questions on temporary exports, you will require a carnet. So again, if you're moving goods, if you have temporary exports outside the European Union, for example, photographic equipment, goods bought in for exhibitions, that sort of thing, you require a carnet. You will now require it for temporary exports to the European Union. And wooden packaging must be ISPM 15 compliant, which is especially heat treated. It's quite interesting is that you speak to some companies and they say this is not going to be too much of an issue, but you speak to other companies and they frantically going away to make sure that all their wooden packaging is ISPM 15 compliant. That's one aspect of it. The other thing is making sure you've got a good supply source because effectively supply could be impacted in terms of especially heat treated, and it must have the IS 15 mark on it, on the packaging, the wooden packaging. So that's the export side. So we've looked at goods either going out of GB or goods going out of EU. Now let's look at it from the other way, so the import side. So if we can have the next slide, please. So imports into the EU or GB. So if there is no trade deal, there could be possible import tariffs. And we have spoken previously on webinars about the UK's global import tariff. And again, please let us know if you want access to back catalogue, so to speak, of information. And happy to take questions on that. We've got a lot of questions today, so conscious we can only get around to a certain number of questions. Import customs declarations required, again, compliance with labelling, packaging, origin of goods. Import VAT payable, unless there is some form of VAT deferment. We're going to look at VAT later. You require an entry safety and security declaration. And again, there's the compliance around wooden packaging. So that's for imports into the EU or to the GB, which are separate customs territory. Now, duty suspension can apply, and obviously we've talked about transit can apply as well. We have covered quite extensively around use of duty suspension, so likes of warehousing, inward processing, and again, please let us know if you've got any inquiries on that, those areas, because they are being seen as key areas and used to alleviate some of the potential impacts post-transition period. If we have a next slide, please. So on the border operating model, which again we've covered extensively, it's a three-stage process. So if you're an importer, first of all, of standard goods, so let's talk about what are non-standard goods. So controlled goods are not are non-standard. So excise goods, alcohol, for example, spirits, military goods, they will require full declarations and full customs processes from the 1st of January. The border operating model has a list of controlled goods, and it was recently updated. And I think in one of our daily bulletins, we provided an announcement on the update, which was received last week. It generally was very the same as the annex to the border operating model, but there was a few changes of terminology in there, which are well worth looking at. So again, on the theme of non-standard goods, live animals, high-risk plants, products of animal origin. We'll look at that on the next slide. So standard goods, the general principle is that traders will be able to defer the full customs declaration for up to 6 months from the date of importation. So if you're bringing in the goods on, say, the 10th of May, you can defer and make the full customs declaration anytime up to the 10th of November. And what you would do is carry out a process called entry into declarants records, EIDR, which some companies may already have if they have customs authorization. When you come to make your full declaration, you will need to be authorized through customs for a process which is called Customs Freight Simplified Procedures, CFSP. And it is fair to say the authorization process for CFP in theory is not simple. You need to have processes written down, documented, and you need to demonstrate some element of customs competency. There is a working group at the moment which the Institute are involved with in terms of trying to simplify the application process for CFSP. So again, please listen to some of the other activity that were in webinars we provided around CFSP. We have talked about it a bit in terms of being potentially a good means of managing your records, your processes from 2021. If you defer, the main benefit is likely you defer the payment of duty for 6 months. So the point at which you make pay the duty, the import duty. So that probably is a big benefit there. But I guess at the end of the day, with trade with the EU, we would very much prefer there to be a trade deal with 0 tariffs. Deferring the duty for 6 months is helpful from a cash flow perspective, but it still means it has to be paid at some way, unless you're using a processing regime on re-exporting, such as warehousing or inward processing. So that's the process with standard goods. From the 1st of July, full customs declarations will be required on any import. Relevant tariffs must be paid on any import. Full safety and security declarations will be required, and full check-in of goods through border control posts in Great Britain. If we move to the next slide, we'll look at the phasing processes for stage 1 and stage 2. So products in stage 1 will have full import controls as well, in addition to controlled goods from the 1st of January. Live animals, certain animal products, and the list is still to be fully produced, fish, shellfish in their products, and certain plants and plant products as well. And there are additional elements here as well, because there are different customs territories that will now apply. So when you have these products come in, they need to be subject to physical inspection. But for the first 6 months between the 1st of January and the end of June, the inspection will take place at the point of destination or approved premises, not at the border. And documentary checks will be carried out remotely. For certain imports of live animals and high-risk plants and plant products, they require pre-notification and health documentation. So you've got the example on the slide there. So why pre-notification? There is a system that's created, and it is being trialed, called IPAFS, the Import of Products, Animals, Food and Feed System, which if you are an importer of these products, you will need to input in by way of pre-notification of the consignment, the country of origin, destination, etc. And that IPAF system is very, very important if you are importing products into this category. Now, from the 1st of April, stage 2, all products of animal origin, so likes of milk, eggs, honey, cheese, for example, will require potential for physical inspection. But again, between the 1st of April and the end of June, that will take place at the point of destination, not at a border control post. But we will require pre-notification, or the UK will require pre-notification. Just as from the 1st of January, a health certificate has to accompany the goods as well. So that would be an export health certificate produced by the authorities of the exporting country. So you've got examples on screen. We will share the slides here. But if you're in this product category as well as products of animal origin, you will require to have pre-notification through IPAFs, and they will be subject to inspections. From the 1st of July, full border control posts will need to take place. In some cases, that may be slightly inland, as opposed to at the border. That will depend on the capacity at the port of arrival. If we move to the next slide, please. So responsibilities for customs declarations and paperwork. We've talked about this a lot, and certainly if you're new to these calls, we're very happy to raise questions here. But this is one of the most, irrespective of a trade deal, one of the biggest impacts clearly in terms of businesses. So, and responsibility does depend on the Incoterms used, what are referred to as the international commercial terms. But trade and customs law requires that it's the trader that has the responsibility. So the selection of the correct commodity code becomes important. And on the slide, you can see there the examples of why the correct commodity code must be used. Everything relates to the correct commodity code. Declaring the correct valuation of goods. So if it's intercompany trade, and not just intercompany trade, then obviously the declaration value for purposes of transfer pricing may differ. And having spoken to many companies that have intercompany trade across the EU, I'm conscious that is an area of consideration. The declarant of record, we're going to look at that in the next few slides. This is so important as to the responsibilities. So we've got two declarations that we've looked at, an outbound declaration and an inbound declaration. Responsibility for VAT. Maintaining proof of export and import, which is full records. So if you have a customs audit, customs will pick out certain of your transactions and they'll ask you for full documentation relating to that transaction, even for small parcels as well. Licenses, if it applies, import licenses as appropriate, and a requirement for safety and security declarations. Now, this is interesting because if we go back before the UK joined the European Community, safety and security declarations were made by the haulier. Certainly on the import side, that is likely to be the case, but we'll look at GVMS and other systems later on. But on the export side, the border operating model that does potentially give some flexibility for the fields, the customs declarations fields, to have additional fields around safety and security. I would stress only some flexibility. That is not entirely clear yet. So just wanted to reinforce that. If you've heard me speaking before, you've heard me speak about this many times, but I cannot stress the importance of it. This is not just about making a declaration, it's everything in the declaration itself. And if you're unsure, the likes of the Institute, we have grant funding available where you can go on courses held virtually currently, which you can access information on customs declarations and what it means for your business. If we have a next slide, please. So Incoterms determine obligations. So it is fair to say when we go to Europe that some of the rules around the best Incoterms to use don't necessarily apply. EU trade has almost become like domestic trade in terms of Incoterms. So the lorry, for example, just proverbially turns up at the suppliers, the exporters' premises, or the lorry moves directly under the remit through a freight forwarder and a haulier to the exporters' premises overseas. So there is some cases not entire clarity as to which Incoterm is being used. So it could be Ex Works, which has maximum responsibility for the European, if it's EU to GB, for the European buyer, or it could be DDP, where there's maximum responsibility for the UK exporter. And that then starts to link into the other country or the counterparty under DDP and Ex Works is responsible to the customs authority of the country. So Ex Works, the European buyer, would be responsible to the UK HMRC, and they would have to have a VAT number, a UK VAT number and a UK EORI number, which will be different from an EU EORI number. And delivered duty paid, and apologies if you've heard me say this before, if you're a UK exporter selling on delivered duty paid, you are responsible for the customs declaration in the European Union. If we move, so you have others such as FCA and DAP as well, which we've referred to previously, but again, happy to take questions on. If we have a next slide, please. So having said that, being a declarant of record is a big undertaking. But we do appreciate in some cases that your European buyer may be trying to force you down that road to try and limit the impacts that they're going to have from post-transition trading. So the declaration is the person, the business responsible for the import. So let's say a UK business using DDP, delivered duty paid. You or they must ensure the goods are legitimate, correctly valued and declared upon import. You are also responsible for any import duty and VAT as well. You are responsible to the European Customs Authority, using this example, for the accuracy of the information, the authenticity of the documents, and the compliance with all obligations, including licenses. Now, clearly, your freight forwarder, your agent, can help you. And if I think of small parcels and the carriers, it's a good example where there is a lot of good support. But you are still legally liable for all this, irrespective of that. So if you are selling under DDP terms, if you're not sure, you need to check. And we would say air freight is probably a particular instance where there is perhaps uncertainty. You need to check and you need to make sure that you are aware of all these obligations and what that brings, even if your carrier, your forwarder, is making a declaration on your behalf. If we have the next slide, please. Okay, so as I say, you have choices in terms of making a customs declaration. You use an intermediary, a forwarder, an agent, a broker. You can make your own declarations, but you would need software badges. But you can apply under the grant scheme if you are considering making your own customs declaration. So you can get support for training, for recruitment, and software as well, if you are intending to make your own customs declarations, but you must be intending to do that. If we have a next slide, please. So in terms of VAT implications, so in the UK, postponed VAT accounting will be available. So it allows effectively offset against your VAT return. And that applies for rest of world imports as well as the European Union. If you're importing into, or for goods that are imported in the EU, the UK exporter will zero rate their exports for VAT, but they must have that full proof of export file. If they don't, then they are liable for VAT as well as a fine from customs if they have an incomplete profile, proof of export. And that includes the evidence that the goods have left the shores of the United Kingdom as well, through the effectively the C88, the proof of export, goods departed message. Import VAT will be payable immediately on importation in the European Union, unless the importer has some form of deferment, for example, supported by a bank guarantee. So clearly, because of that cash flow impact, yes, the importer will be able to offset if they're making the customs declaration, but they've got that immediate cash flow impact. So discussion is needed with the importer. And as I said, if you're selling as a UK exporter on DDP terms, you are responsible for the VAT, and you have a liability to the customs authorities in the European Union. In some countries, that requires a fiscal representative. For example, France, some of the countries in Central and Eastern Europe, and there are others. If we have a next slide, please. So in terms of triangulation, I just wanted to bring this in. So those of you that are familiar with triangulation, unless it's covered specifically within a trade deal between the EU and the UK businesses will no longer be able to benefit from triangulation simplification. So effectively, what the UK business there, using our example of France, UK, Germany, would need to register, would need a French VAT registration. And France, you need fiscal representation as well to go with your French VAT number. So if you want to continue to access triangulation, you will need a VAT registration number in the appropriate European countries. If we have a next slide, please. So GB to NI trade, just by way of summary, customs declarations for goods entering NI, yes, that will be required. The scope of the declaration is unclear, so this is GB to NI, because Northern Ireland is also part of the customs territory of the European Union. The island of Ireland is the customs territory of the EU. Northern Ireland is also the customs territory of Great Britain as well. But the point of view here, goods are entering the customs territory of the European Union. Hence, customs declarations are required. As I say, the extent of those declarations is still under discussion. Safety and security declarations are also required on goods exiting the UK and entering Northern Ireland, and at-risk goods could be subject to tariffs if tariffs apply. And goods, products of animal origin, for example, will require SPS sanitary, phytosanitary checks. Now, there will be announcements on support for businesses impacted by GB to NI trade. So if you are based in Northern Ireland, there will be announcements on support packages. And that will be made over the coming weeks. If you are a GB trader selling, for example, on DDP, Incoterms, and you are responsible for that inbound declaration, again, there may be support provided for you as well. So await further announcements in that respect there, and we will be hopefully working with businesses to support you in that regard. If we have a next slide, please. So we have another poll, and I'll hand back to Will now. Thank you.
Many thanks, Kevin. And the next poll is basically one for goods traders in particular, and it's asking how will you go about completing customs declarations, and the options there range from I am already able to complete them, I plan to learn how to complete them, I will hire an intermediary to complete them for me, I export goods but I am not yet sure, I export goods but I will not need to. And for those services companies on the line, we do have a services question lined up for later on. So please feel free to just ignore this question and listen in, because Kevin, we're getting lots of questions coming through. I'll start with one from the audience and then move to one from myself, just picking up on something you said. Bradley asked, I know TSP, Trade Simplified Procedures, I think that is, were suspended, but there was talk of reintroducing it in January. You only talk about CFSP, but not TSP. Therefore, will TSP definitely not be implemented in January or in the future?
Yeah, so just to confirm, TSP, Transitional Simplified Procedures, was brought in the event of a no-deal Brexit last year. So TSP, if you like, is no longer on the table. It will not apply. If anything has changed, it's the phased import controls announced also as part of the border operating model. So to confirm, TSP will no longer apply.
Thank you, Kevin. And just a quick note on questions, loads of good questions coming through. We will probably not be able to answer all of them today, and we'll have to take a fair few offline. Generally, our principle is that we ask for questions which are relevant to the broader audience, so anything just more company or sector specific. Those are the sorts of questions we might take offline afterwards. But thank you for the questions, really good stuff. And just to share the results of that poll, so over 50% are looking to hire a customs intermediary. However, 18% can complete declarations, 18% are planning to learn. And for those companies planning to learn, Kevin, you touched on the customs grant scheme. I know there's an announcement recently from Michael Gove, I think it was, regarding £50 million of additional funding. Could you just say a little bit more about the funding and who is eligible for it and what sorts of courses it can be used against?
There was initial £34 million of funding around capacity building, around customs declarations and procedures. That's all been used up, and now there is 50 million. If you've applied, I guess, before the cut-off date at the end of July, the rules of the previous scheme apply. So currently, if you are a trader, you can apply. If you're clearly a freight forwarder and intermediary, you can apply as well to PwC, who are the grant holder. There are details on our website, and we obviously can make them available, and we do, on terms of how to apply for the grant scheme. So the grant scheme can be available for training, education, so whether that's the UK Customs Academy, the Institute's qualifications training, and also some areas around post-transition planning as well. It can also be used. It can be used to link towards customs procedures, whether that's CFSP, warehousing, inward processing, anything that upskills, creates capacity to actually meet impacts. So please, if you're considering customs declarations, then do look at the grant scheme and the benefits, and even just to understand what the impacts are, the liabilities are for traders, becomes extremely important, because it is you, the trader, who's responsible. As I say, if you're working with a customs intermediary, then then liaise with them and work with them as well. Thank you.
Thank you, Kevin.
Okay, GVMS. So GVMS, effectively the concept of GVMS, and it is a system that's under development, and it's currently thinking it's a HMRC system, will link declaration references together. So without getting too technical, that's from the current customs declaration system chief, whether that's from transit, under as transit procedures. And the idea is it links it all together to create a single goods movement record, a GMR. And the carrier, or the haulier, just requires that one reference. So the idea is to avoid a situation where the haulier turns up at a port and has to sign lots of documentation, has to go through lots of checks. The idea is to take it away from the border to try and make the situation as electronic and as pre-authorized and pre-lodged as possible. So that is very much some of the principles around GVMS. There's also additional work announced in the border operating around smart freight. And the idea of smart freight, which I know Kent is always talked about, and it is probably the most important, is to try and alleviate, if you like, the queue of lorries, proverbially speaking, at the border and at the port as well. So to try and come through to some process where everything is pre-authorized before it gets to the port. Thank you. And you've got a web link there which provides the HMRC details in terms of GVMS. Thank you. So we have a next slide, please. So rules of origin. This is a big area for some businesses. The basic principle is you have non-preferential and preferential origin. A lot of focus is on preferential origin, but non-preferential origin also becomes important in certain states. So where there's trade disputes, the embargoes, and this morning there was an announcement on Hong Kong as well. So that could have some big impacts for certain exporters. So non-preferential origin countries that you can trade with, you have to demonstrate the origin to make sure it's not of a country where there is non-preferential origin. But preferential origin is what's being talked about from a transitional period impact. So if, for example, you're a UK company selling to an EU exporter, and that EU exporter is exporting outside the EU to a country that the EU has a trade deal with, so let's say Morocco, South Africa, Mexico, Japan, and Singapore, and so on, and yesterday there was an announcement on Vietnam as well, then that has to meet the origin requirements of the EU trade deal, which could be 40, 50, 60%. But if it's all UK origin, the EU exporter is not going to be able to meet those origin requirements. So you do need to look at who you're selling to as well, in the UK and in the EU. It all has an impact throughout the whole supply chain. So supply chains could alter in certain sectors because of this. Likewise, do you have a lot of EU origin in your UK content if you're exporting outside the European Union? So again, if UK exports to Tunisia, to Morocco, for example, there. So in the event of a trade deal between the UK and the EU, zero tariffs, if they're agreed, there should also be agreement on rules of accumulation as well. So if, for example, you get a lot of your goods from Europe, and then you're taking them in, you're then selling them on to Republic of Ireland, the rules of accumulation will apply, which should take away some of the origin impacts. We would also stress in that impact, consider warehousing or inward processing if there is no trade deal between the UK and the EU and tariffs apply. Again, happy to provide further information on warehousing and inward processing and the benefits it can provide to your business. So I'm conscious that's just an overview, but I just wanted to point out. So if you have a lot of foreign content or European content in your production process, so you're exporting into the EU and it's going outside the EU, do think of it from an origin perspective. If we have a next slide, please. So now let's move on to service exports, and if we have a next slide, please. I would stress that some of what I've said today already when I talk about small parcels applies to services as well, where there's a physical element. We're going to look at GDPR, we're going to look at intellectual property, and we're going to look at EU settlement scheme. Just want to pick up on a few other things here. One of the big discussion points in the EU-UK trade deal will be the recognition of professional qualifications, which I appreciate to some of you on the call, your professional qualification status is very important for your ability to sell a service. So that is very much got to be discussed. Definition of a short stay without a visa. Last year, when we were potentially discussing a no-deal Brexit, The offer from the European Union was a short stay without a visa would be determined as 90 days in any 180-day period. That still has to be negotiated and agreed as to what that looks like. And driving in the EU is likely or will require a green card, and insurance requirements will vary, and even green card will vary by individual country. VAT on trade-in services is based on the place of supply rule. So if you are supplying and say a VAT registered business in Italy, for example, the place of supply is Italy, you zero rate your export and the VAT is paid by the Italian exporter. That does not change. Post-transition period, that is exactly the same. If it's a B2C, then you will charge, or a non-VAT registered business, you will charge VAT. So the procedures around that don't change for trade-in services around VAT. Access to European markets. This is a key one for certain sectors. So if you're in digital, broadcasting, and other sectors, even financial services clearly, and business services, is services need to be agreed the access in the trade deal. It's not just about trading goods, it's trading services. And there's been very little commentary on that. It's all about trading goods, unfortunately. That's what's discussed. The fallback position is the general agreement on the WTO general agreement on trade-in services, which has 4 modes agreed at a WTO level around the ability to provide services, the ability to travel to deliver services, the ability for someone to consume services. And generally amongst WTO members, there is an agreement to provide these services. However, it's on an individual country basis. So if there's not a UK EU-wide trade-in services deal as part of a trade agreement, it will be down to an individual country basis. A final point on encrypted software. If you are provided encrypted software, that may require an export license, an open general export license. And if you are exporting to the European Union, the likelihood is you will require an export general license for your exports, such as obviously encrypted software. The challenge is if it goes through the cloud, how does anyone know? You should declare it. And again, we have an export control profession which also focuses on export encrypted software as well. If we have a next slide, please. So the EU settlement scheme. So many of you will be familiar with this. Since the launch of the scheme last year, 3.71 million applications, 3.6 million have been granted for settled status, 57%, pre-settled status, 41%. You've got the link there in terms of at the top of the slide in applying. You can now apply through both an Apple iPhone and an Android device as well. So key message is get your EU nationals to apply before the end of this year to avoid having to fall back or to work within the new immigration, points-based immigration system where you have the link on the slide. If we have a next slide, please. So data protection, this is a big area and we still don't have final conclusion on it. We are trying, the UK and the EU, to sign an adequacy agreement, but there are discussions here. So businesses can't necessarily work on the basis that there will be an adequacy agreement. Similarly, you can't work on the basis there'll be a zero tariff trade deal as well. Do look at the guidance from the Information Commissionaire's Office, ICO, and do make sure that you're applying standard contractual clauses. You've got the link there. You go through the process of handing standard contractual clauses, because if you don't have them and there is no adequacy agreement, your ability to hold data on addresses in the European Economic Area, the wider European Union, could be impacted. There's guidance here for small businesses on this site, and there's guidance for large businesses. If you're a large business, you may consider binding corporate rules in the group company structure to hold data. But a key area, so do look at this. There's a real need now to continue to look at data protection and not forget and work on the basis that everything will be resolved by the end of the year. If we have the next slide, please. So coming to the end now, so just on trademarks, there will be a new UK trademark and effectively a mirroring cloning of current trademarks. If you have a pending EU trademark application, you will have 9 months to file a UK application, which mirrors your EU application and has the same benefits. So if you're holding trademarks, there will be a cloning process. If you're applying for a trademark, then do consider obviously where you are in that application process before the end of the year. So if we have the next slide, please. So finally, post and parcels. I'm probably not, in terms of time, not going to cover this too much, but basically customs declarations are required, even if it is a bulk declaration by your carrier, for example, you still require to have the information. Happy to take questions on that point as well. And if we have the next slide, please. So, and just to confirm, for imported goods, this is a major change made. So VAT will be payable by the overseas supplier for goods not exceeding £135. Yes, a forwarder can do it on their behalf, but the overseas supplier should be VAT registered in the UK and accountable to UK customs for VAT. That is a major change there. And low value consignment relief, £15, is being withdrawn. Okay, so that covers the end. I'm going to pass it back now for a poll, and very happy to take the lots of excellent questions. Thank you.
Thank you, Kevin. And as mentioned earlier, we will be doing one last poll. This one is for services exporters, and it is asking which fees you consider the biggest potential issue. The options include data flows and holding of EU data, EU nationals currently working in the EU, additional barriers on trade and services from some EU members, or recognition of professional qualifications. I will go straight into the questions while people are answering that. We've had a couple of questions on rules of origin. So one from Lucinda has asked, for products we are going to export to the EU, would it be advantageous if raw material came from the EU from a rules of origin perspective? And Mike has asked, is there any more information on accumulation, please?
Yeah, so I'll just take the second question. On the concept of accumulation, the EU has accumulation agreed with all their current trade deals, which is why the working principle is it shouldn't differ from the UK there. So accumulation is where EU content is taken into UK content when it goes back to the EU, for example. And it's agreed with, it's in other trade agreements as well. It's not just would be just the EU UK. With regard to EU content, would it be better to have it, not have it, etc.? Clearly, it does depend where supply chains are and quality and relationships as well. It depends if the UK can negotiate in their trade continuity agreements EU content as part of ongoing UK content for origin purposes. So in the South Korea trader deal, the UK has agreed for 3 years that EU content can be agreed in the trade deal, but that may not be the case for every trade deal, which is why companies have to look at the individual, have to plan, and to stress possibly whether it's grant funding, consider supply chains and origin as part of your planning process. Thank you.
Thank you, Kevin. Just going to show the results to that poll quickly. 38% additional barriers on trade and services from EU members and 27% data is the big findings there. Just another question from Andy, who's asked, is it the case that a UK importer would have to be a CFSP trader? And if not, then full declarations will be required at the border each time by the presumably the forwarder.
Yeah, so a couple of things there. If you're using the phased import controls, EU to GB, then you can be effectively, you have to be CFP registered, but your forwarder, your broker can do it on your behalf. And under the rules for EU trade, for UK traders, the forwarder will not be financially liable. If the forwarder is making the declaration under CFSP for an EU trader, they will still be financially liable, but for a UK trader, they will not be. So your forwarder can make the CFSP on your behalf. Clearly, you'll need to discuss the commercial arrangements in that respect, but your forwarder can make it on your behalf. So, but CFSP is mandatory, if you like, where you're deferring the declaration. But CFSP is something all businesses probably should be considering anyway, in a lot of cases, because there are benefits of CFSP in terms of cash flow and in terms of supplementary declarations as well.
Thank you, Kevin. Sarah has asked, what will happen to the EU R1 certificates? Has a replacement been agreed?
So what will happen there is there will be a new UK certificate of origin. And it's fair to say that announcements are awaited in that respect. So EUR1 to a large extent will no longer apply, and there will be a new UK certificate of origin.
Thank you. A question from Linda, and we've had a few on AEO. Linda has asked, do we know what will happen with the current AEO authorization after the transition period finishes?
So there needs to be mutual recognition of AEO between the UK and the EU, and also for safety and security purposes, where the EU has mutual recognition schemes with the likes of China, US, Norway, Switzerland, Japan, and the Faroe Islands. So it needs to be mutual recognition agreed. AEO still exists because AEO is a global scheme from the World Customs Organization. It's not an EU scheme. So AEO will still exist. We're trying to work with government to try and get further benefits from AEO in terms of this sort of trusted trader concept as well. So the clarity of the benefits of AEO become a lot clearer and move just beyond financial guarantees to actually implementing it. So that's something we're very keen on, to make sure that AEO is interpreted to have wider benefits, which was the original effectively requirements at a world level.
Thank you, Kevin. A question from John, and hopefully tease out some of the technicalities of Northern Ireland protocol. He says, we purchase goods from Germany, France, Netherlands for customers in Northern Ireland and Republic. What will be needed to continue doing this? Will the routes that these goods take have any effect, i.e. if it comes through GB or from EU to mainland or to Northern Ireland?
Yeah, good question. So just to be clear, any goods that go from EU to Northern Ireland through the English Channel, for example, were not touching the land bridge of Great Britain, will not require any declarations, any tariffs, because it's EU customs territory. If it comes to the UK, I guess it depends what happens. So if it comes under a transit procedure, depending on the interpretation of transit, then in theory, it's declaration at the authorised consignee's location. But it does require an interpretation of transit. And through our various contacts with HMRC and the JCCC, that has been raised as a specific question, and further information on operation of transit will be advised. You would sincerely hope that in transit would be interpreted positively there.
Thank you. We'll do a couple more questions. Michael has asked, are there any specific changes in regard to customs comprehensive guarantees and IP special procedures?
So
processing, I think.
Yeah, so I've talked about simplification for CFSP to try and make sure more companies can benefit from the advantages of it. With regard to CCG's customs, the border operating model refers to, and again, we had an update from customs yesterday in this respect in questions that have been posed, that effectively customs comprehensive guarantees would only be required for high-risk traders. But the full definition has to be announced, and that was what yesterday was saying, as to whether, so if you're not a high-risk trader, what circumstances would you be defined as not requiring a customs comprehensive guarantee? This is significant because trying to get a financial guarantee sometimes from banks can obviously be time-consuming and obviously difficult for some businesses. So if customs comprehensive guarantees are not required, then that, or financial guarantees, sorry, are not required to support CCGs, then that could be a big benefit. So the definition is still to be fully announced, and the criteria. If you're a high-risk trader, however, with a history of non-compliance and poor record keeping, clearly you will still require a guarantee.
Thank you, Kevin. And we'll squeeze in one last question from Gaynor, who's asked, can you confirm if Intrastat reporting is still required if a business is making import declarations in chief at the point of import for all EU to UK transactions?
So the answer to EU to GB, the answer is Intrastat is still required, yes. In 2021, and the reason for that is record keeping. Beyond 2021, I think we're waiting final clarity, but 2021 Intrastat is still required because it is the main means of record keeping in terms of statistical purposes.
Thank you, Kevin. And on that note, I think we will have to wrap up. It's been an hour, so thank you once again to Kevin for the presentation and the answers. I hope everyone has found that useful, and we will look at how we can follow up all of the various other questions we have received today. And we'll also be looking at sending through the links included in the slides, as well as the slide pack and the back catalogue, which Kevin mentioned, of previous webinars. Just to finish off on, the Institute delivers a comprehensive suite of training courses covering all the aspects of exporting and importing, including completing customs declarations, which will help you to prepare for new trade rules next year. Many of these courses can be fully funded by government grants, and we really do recommend not to miss the opportunity to get funded training as part of your preparations. Membership with the Institute also gives you a range of benefits, including access to our technical helpline, discounts on training, a wealth of online resources, our daily bulletin with all the key trade stories, continuing professional development, industry recognition, and maybe even some networking opportunities in the not too distant future, we hope. To find out more about our training and membership offerings, please visit the site at export.org.uk or feel free to get in touch at institute@export.org.uk. For now, though, thank you for tuning in today. We hope you found this session useful. Please do take the exit survey to let us know what you thought and to suggest any future topics we could cover. But for now, goodbye, everyone.